from Topeka for today. Well, today, Miss Revenaugh comes to us from Topeka. Ladies in the back, we're going to start. Miss Revenaugh comes to us from Topeka and is the owner of say it again. Revenaugh and Revenaugh. This woman-owned micro-business offers personalized legal services across a wide range areas, including personal injury, criminal defense, and estate planning. This law firm defends individuals facing challenging circumstances, and advocates for equality and justice, especially supporting those in most, such as single mothers, immigrants, and marginalized groups. Nicole was a Shamberg Scholar at Washington University School of Law, graduated with honors in 2012. She marched for women's rights in Washington, D.C., 2016. Thank you. Nicole belongs to many associations, including the Kansas Women's Attorney Association, and is treasurer of the Kansas Women Attorneys for Freedom. Today, she will discuss the constitutional amendment regarding the election of Kansas Supreme Court justices, which we'll be voting on August 4th. Thank you for coming, Nicole.
That's what she said. Okay, how's this? Good? Okay. Well, good afternoon, everyone, and thank you for inviting me to Great Bend. I have been here several times before. I actually have had some clients from Great Bend, and so from time to time, especially before COVID, before Zoom and all that, I made some trips out here. So it's great to be back. As Janice said, my name is Nicole Revenaugh, and I have a law firm in Topeka. We focus on civil litigation, but more importantly on protecting civil rights and constitutional freedoms, which most recently has included our voting rights and equal protection under the laws in Kansas. I want to thank you all for inviting me and my organizations to speak today on obviously what's become a very important topic. But before we talk about the amendment itself, I'd like to spend some time going over the history of our courts, the ins and outs of how they work, and how the proposed constitutional amendment would basically jeopardize the ability of our citizens to keep our courts free and separate from any political influence. I also love engagement and discussion, so hopefully I've left enough time at the end for us to just talk, do Q&A, that kind of thing. So if you have some questions, hold on to them and we'll cover all of those at the end. As Janice mentioned, I wear many different hats in the legal community, and so I feel like when I speak on the presentation, I'm here on behalf of two organizations. First, the Kansas Women Attorneys for Freedom, and then Kansas United for Impartial Courts, which goes by KUIC, K-U-I-C, and that's some of the materials you have back there. So first, KWAF, Kansas Women Attorneys for Freedom, is a collective of attorneys from across the state, mostly women, with a unified mission of advancing, promoting, empowering, and protecting women in whatever arena that arises. With regard to the judicial system in particular, one of KWAF's primary objectives is to support the independence of the judiciary, including the preservation of our merit selection process to appoint our judges and justices. And that merit selection process is the issue on the constitutional amendment that's proposing to be changed. Then KUIC is a brand new organization. It was formed directly in response to the Kansas legislature passing the concurrent resolution that requires us to now have this vote in August on whether to change how we select our Supreme Court justices, again, from a merit-based appointment system that we have now to changing to a purely statewide election process with political party affiliation. KUIC has done some massive fundraising efforts. They put a professional campaign team together whose only focus is on defeating this amendment in August. And it includes various committees, lawyers, retired judges, professors, teachers, and many other stakeholders who believe that an election-based system is not what's best for Kansas. And I serve on one of Quick's legal advisory committees. So that's kind of how Janice and others and Ann got in touch with our organization, because we're going around, there's a group of us who will give these presentations across the state, because we really believe that first and foremost, education is the key. And if we're able to educate each other and our friends and neighbors, voters, members of the public, then we do believe people will see that there is a clear choice for what's best for Kansas and our court system. So I am big on roadmaps. I know I get to talk up here for a little bit, so I want to tell you where we're heading. And this is kind of a 30,000 foot view of what our discussion is going to be today. And like I said, I think it's important that we first talk about the history of our courts and the role the Kansas court system plays in our daily lives, and how we even came to institute a merit selection process and how it works, who serves on these commissions, and how does one successfully apply for or be selected to be a judge or justice in our state. And then we'll talk about the role of Kansas citizens and how we participate in what we call retention elections. And that's where we have the ability to vote on whether a judge or justice should remain on the court for an additional 4 or 6 year term, depending on what court they're serving in. Of course, we're going to talk about the constitutional amendment. Don't worry, I didn't leave that out of the discussion. And it's coming up soon. We have less than 4 months. It is on the August 4th primary ballot. You can vote for it early, just like you could do early voting for other things. So I don't want you to think that there's just only singularly one day to vote. But of course, our August 4th primary, just like any other primary, is going to contain that constitutional amendment question. And it proposes to change, and I'll say this so many times today, and it's not because I think you don't hear me the first time, but just get comfortable with the language, get comfortable with how do we explain this to people outside this room. And the proposed amendment wants to change the selection of our Supreme Court justices, specifically from merit-based, nonpartisan selection process to basically an open statewide partisan election, like we have for US Senate, like we have for the Attorney General, like we have for the governor's office. So then finally, we'll talk about what the potential impact is if the ballot succeeds, if the ballot measure succeeds. What impact would a statewide election system have on our courts here in Kansas? How would it affect our ability to ensure that we have fair and impartial courts that are free from political influence? Or can we accomplish that if this amendment passes? So back to the beginning of high school civics. Just like the federal government, we have 3 co-equal branches of government here in Kansas. The legislative branch is our state House of Representatives, our state senators. They obviously make laws, they pass bills, they're submitted to the governor for either approval, a veto, or I guess a non-action, where it could become law without the governor's signature. But of course, that's their function. That is the legislative branch. The executive branch, of course, includes our governor, all of our state agencies, her administration and cabinet members. And their job is to enforce and carry out the laws and to develop policies for carrying out particular laws in a certain way. So then, of course, the judicial branch is our referee, right? Their job is to interpret and apply the law to a specific situation involving the parties before them in a particular case. Sometimes it has broader implications for the entire public at large. Sometimes their decision really only solves a dispute unique to the people who are sitting in front of them as litigants. So let's dive more into our judicial branch. We have 3 levels of courts in Kansas. Our district courts, which is the lowest level court, or like introductory court, they're divided into 31 judicial districts across the state. And thankfully, even though there's only 31 judicial districts, we do have a courthouse in each of our 105 counties. So many of the counties may be bundled into a particular judicial district, but everyone has access to a county courthouse wherever they reside. The district courts, like I said, they're usually the first court to hear a particular case or grievance. If I'm accused of a crime, my case is usually tried in the district court. If I need to file for divorce or I want to adopt a child, that also is a process that goes through the district court. Then our intermediate court is the Court of Appeals. It has 14 judges, and they hear appeals from a party that usually lost at the district court level. And they'll handle both civil and criminal cases. The Court of Appeals usually handles their dockets in groups of 3. So instead of one judge, which at the district court level, you're just dealing with one judge hearing your case, but you don't like the outcome or you think the law wasn't followed properly, you can appeal. And at the Court of Appeals, you're usually dealing with a panel of 3 judges who hear your case on appeal. There are also some situations, especially dealing with a broad statewide implication of the outcome, where you can hear a case en banc. And that's not spelled that way, but that's how it's pronounced. And that would mean that all 14 judges actually sit and hear a case together and can then vote and make a decision on the outcome. Of all 3 levels of courts, the Court of Appeals actually has by far the largest caseload to deal with. And that's because as a matter of your constitutional rights, especially a criminal conviction, you have a right to appeal from that conviction. And so if you are convicted of a crime, if you feel like you got a particularly harsh sentence, shoot, if you feel like you got a lucky 7, in the mail that day, you can appeal your case and just hope that there was something that the Court of Appeals thinks wasn't followed properly. You can get a new trial. You could have your sentence reduced. There's all kinds of outcomes you can have. And so for a lot of the reason the caseload is so high, I think, is because a lot of criminal defendants really just have, there's no harm in trying. There's no harm in trying to appeal their case. And so they do have a really voluminous caseload that they have to deal with. And they receive appeals from all 105 county decisions, all 31 judicial districts. So they really have the horse's workload of the courts. And then finally, we have our highest level of court, which is our Kansas Supreme Court. It's made up of 7 justices, and they have jurisdiction to interpret our Kansas Constitution, and which in most ways does mirror our federal US Constitution. So it is a separate document. It was created separately by people of Kansas when we became a state, but it does in many, many ways just mirror what the US Constitution says. Now, it has not always been interpreted the same way our US Constitution has been interpreted, and so that's one unique difference there. But we do have our own state constitution. The Supreme Court also will interpret statutes that are passed by the Kansas legislature. They determine whether those statutes are constitutional, whether it violates a certain group of people's rights to due process, for example, or equal protection of the law, which means, is this law being applied equally to every class and member of our state, or does it favor or especially harm one particular class of individuals, things like that. They also, let's see, they're always the next level of appeal. They are the highest level of appeal after the Court of Appeals. So if you lose in the Court of Appeals, you can also file what's called a petition, and you can petition the Supreme Court and ask them. It's not an automatic right now. Once you get to the Kansas Supreme Court, you have to ask them, would you please review my case? Would you take this on appeal again? And they can't say yes to every case. They don't say yes to every case. So in that way, it does mirror our US Supreme Court that says, I get about 1,000 requests to take a case. I'm only gonna take about 65, 100. I don't know exactly how many our state Supreme Court takes, but they are allowed discretion on what they decide to take up on appeal and what cases they want to hear. When the Supreme Court makes its decision, our Kansas Supreme Court, that is a binding decision. Unless you are one of, like I said, 65 cases that is appealed to the United States Supreme Court and gets selected, usually what the Kansas Supreme Court says is final. Now, there are some cases that do get taken from the Kansas Supreme Court up to the US Supreme Court, because that is your last and only chance, is can I get federal relief of some kind? But it's very unusual. It's very unusual. So usually for folks like you and I, having normal disputes, having a criminal conviction, unless there was something particularly impactful nationwide, or that the state's rights were so horribly violated that only the US Supreme Court can come in and help, that generally the Kansas Supreme Court is going to be the last court of last resort for Kansas. So let's talk about how our judges make it to the bench. Kansas is a little unique in that our state district courts have multiple ways. We follow multiple systems to select our lowest level court district court judges. One of those ways is through partisan elections, which is the issue that's on the ballot this August, right? Do we want to also do partisan elections to pick our Supreme Court justices? Right now, there are several counties and jurisdictions, including Barton County, the 21st Judicial District, where you all have partisan elections to decide who will be your local district court judges. Sedgwick County has 30 district court judges. They're all selected by a partisan election process. Wyandotte County does the same thing with their judges. And every county in the 20th Judicial District where Barton County sits, so that's Ellsworth, Rice, Russell, and Stafford counties, also do partisan elections to pick their district court judges. Those judges have to run for election just like any other candidate on the ballot, right? Have any of you had a judge like come door to door and talk to you, or be in an event, someone who's either running for, they don't? Okay. Do they even have opposition here? Usually not. It depends. Okay. That's really common too. There's a lot of folks that once they get in, they have to file for re-election, but like they don't generally have a big opposition. So it really is just kind of unique to the community, I think, and whether, because in Sedgwick County, there's people that run against each other all the time, right? And it's probably very stressful, especially if you got in, you're on the bench, you're a judge, and then 4 years later, you kick back off. I mean, it's a lot of work just to be removed 4 years later. So I just want to point out that let's see, 14 of our 31 judicial districts do partisan elections, again, for our district court level judges. The other 17 districts, which include Douglas County, Shawnee County, Johnson County, they have a merit-based system of appointment, which mirrors pretty much this system that we have now to select Supreme Court justices. And so the process of going through a merit-based appointment at the district court level looks like this. There's a vacancy that opens up on the court. Sometimes that's retirement, illness, death, or just, I'd like to resign, I'm finished with this job. And so once there's a vacancy, that's posted to the public. There's no secret, I guess, horse trading behind the scenes about who's going to be this judge, what's going to happen. It's a public notice that's published that says, hello, we have a vacancy in this judicial district. This is where it sits. If you'd like to apply, here's where you submit applications. So judges and attorneys, because, just because you're a judge doesn't mean that you're a judge in a particular court that you feel that you should be or have a good fit, or maybe you move and reside in a different district. So attorneys and judges can apply to be on the district court. They file their application, and then there is a nominating commission. That nominating commission for the district courts is made up of folks who live in that judicial district. So this is not a Topeka-based thing or a Johnson County-based thing where you have strangers in Kansas City picking who Barton County, well, not Barton County, you guys elect, but pick who judges are in different districts. That nominating commission is made up of your citizens, your residents, mostly attorneys, but not all attorneys. A lot of district courts have a grouping of lawyers and non-lawyers to help review candidates and select finalists. So that's where the commission goes through kind of like an HR application process. They're going to review the packet. They're gonna do background checks. They're gonna look into your references. They're gonna see who's sending in letters of recommendation supporting your candidacy to be a judge. And then they do interviews with you, and in many cases, those interviews are public. You can watch them on YouTube. It's kind of like watching the boring city council committee meeting, you know, the water board, but you can find it. It's there. It's there on YouTube. It's public, and they're supposed to do their deliberations in public too, which I know has been tricky for some folks that sit on the commission because they don't want to disparage publicly a particular candidate, but they also have no interest in like voting to promote that candidate for the position. So it's very interesting to hear them go through the process, but it's all public, it's transparent, and I think that's really important. I think that's something Kansans really focus on in our government. So right now, the merit-based process for district courts and the Supreme Court is all public process, and it's accessible to watch on YouTube. So once the nominating commission finishes their process, they are going to select among all the candidates, applicants, 3 finalists. These are the 3 folks we think came in the top in our voting. And so we're going to submit those 3 finalists to the governor. Then the governor, whoever he or she may be, will do their own background and vetting check and interviews and receive letters of recommendation and things like that. And then the governor's office will choose which of the 3 finalists they want to appoint to the court. And once that selection is made, that person is then, you know, sworn in under oath to sit on that vacant seat. So that in a nutshell is the merit selection process. And that's what 17, it's about half, you know, 17 of our judicial districts follow merit-based selection, and then 14 follow the election, just a straight open partisan election process. So again, this is all our district court, our first level of courts, how our district judges are picked in Kansas. So then let's talk about the intermediate court. How are the Court of Appeals judges selected? This process also contains a nominating commission, and it's not split. The Kansas Court of Appeals doesn't have, I guess, geographic residency requirements. It's not split into districts the way the district court is. So you could have a judge, if there's a vacancy, any person, any qualified person residing anywhere in the state can apply to be on the Court of Appeals. Their office, the courtroom, you know, their judicial offices are in Topeka, but I know that there are some, there's a group of them that have like, not court and residence, but they do a lot of work from Wichita, for example. So it's not required that they're there in Topeka 24/7. They could still be part-time in the communities that they reside. So again, they also go through a nominating commission process that interviews the candidates, and they narrow down the field to the 3 finalists in the same manner as I just talked about with the district courts. But what's different about the Court of Appeals is that after the governor chooses, I have 3 finalists, I've made my choice. I'll use Chief Judge Sarah Warner as an example. She's the Chief Judge of the Court of Appeals right now. So Governor Kelly said, I choose you, Sarah Warner, to become a judge on the Court of Appeals. The Court of Appeals is unique in that that's not the end of the road for Ms. Warner. She still has to be approved on an up or down vote by the Senate. So our state Senate goes through a confirmation process, just like you see in the national news with our Supreme Court justices. They sit there and they're grilled by the Senate, good and bad. The Kansas Senate also goes through the same process. And then they have a yes or no vote as to whether they approve of this pick, and then that person can be seated on the Court of Appeals. Our Kansas legislature, for the most part, will approve these picks, but they have notoriously rejected 2 individuals. One they rejected twice in a bit of political bantering. So it was Carl Folsom from Douglas County. He was selected by Governor Kelly, but he was a public defender. Kansas legislature doesn't like that very much. I don't think that's fair, but that's how they felt. And so they rejected his nomination. Governor had to choose someone else. A different seat came up again, and Mr. Folsom applied again, was a finalist. And in only what can be called a political chicken match, Governor Kelly picked Mr. Folsom again. And the Senate rejected him again. So it's just interesting when you have that that last layer is a political layer, right?
Mm.
It's not merit-based. The Senate is going through, I guess, some kind of character and questioning and interrogation test, but at the end of the day, they make what I think is a kind of a partisan political decision on whether they want a particular person on the court. So it's just one way I want to show you that the Court of Appeals is unique and that they do have this political angle to the process at the very end. And a lot of times it's no harm, no foul, and people scale right through. But every once in a while, there's an issue. And when there's an issue, we've actually had nominees rejected, and the governors had to pick someone else to be on the court. And then finally, the appellate judges, they sit for a 4-year term. Okay, so our Supreme Court justices we'll talk about sit for 6 years at a time, but the Court of Appeals is 4 years at a time. Okay, and then finally, our Kansas Supreme Court. That's what we're here to talk about today anyway. The Kansas Supreme Court was actually established as part of our state constitution when we became a state in 1861. And that's really important because when something is created as part of our state or federal constitution, you can only change it through a constitutional amendment. So it's one of our ahas. Why are we voting on this ballot measure? How come the legislature didn't just change the law on how we could vote for these judges? And the answer is because the Supreme Court was made by the process, during the process, creating our state constitution. And so that process of how they're selected can only be changed by an amendment to our constitution. When the Kansas Supreme Court first came into existence, we only had 3 justices. And that's because we didn't have a lot of people. You know, we were still settling Kansas and getting established as, at that time, a very progressive state. I like to remind us that we were a very progressive state when we came into the Union. We had the first woman mayor, not the first woman governor, but many firsts in the early days of Kansas that we should be very proud of. But we had 3 justices. 15 years later, 20 years later, in 1900, the people passed a constitutional amendment to expand the number of justices to 7. And from what I have seen, that was not politically nefarious of any kind. It was just our population was growing. We needed more justices. And so it became 7. It's still 7 to this day. So that number is held now for 125 years. And very interestingly, our Kansas Supreme Court at first was a full-blown partisan election process to pick our Supreme Court justices. That's what our legislature is proposing that we return to. Let's return to the original constitution that said we were going to do partisan election of our Supreme Court justices. So just like any other election, the justices were picked by popular vote as to who was going to serve on the Supreme Court. But there was one very important exception to that rule. What did you do if there's a vacancy that comes open on the Supreme Court and you don't have an election coming up right away? What do we do? What if in December of this year, right after our election, someone passes away, has an illness, is incapacitated, can't serve on the court anymore? Are we just going to leave the seat open for 5 more years because it's a 6-year term? And that answer was no. Now, I don't know why, but at the time, Kansas didn't do special elections and runoffs like we do now, right? If we had a very important vacancy, we could call a special election and then it'd be a random day, but we'd all go to vote on a particular issue. There's different states that do that. We didn't do that back then. So if we had a vacancy on the Supreme Court, the governor would be allowed to appoint someone to finish the term. Okay, and that person would hold the seat until the next logical election cycle for the person that the seat who they filled. Then they would sit for election like anybody else. But that governor appointment is very important. So this system, for the first like 50 years, going all the way back to 1861, 80 years, it worked really well. There wasn't a lot of issues. People were generally happy. But then in the mid-1950s, there was a major shift in attitudes about the court due to a notorious scandal, right? We have to have a scandal to talk about how we got here. And that scandal is called the triple play. So here's what happened in the triple play. So in 1956, Fred Hall, who's the governor of Kansas, he lost his bid for re-election. But the governor refused to accept that his time in power was over. It sounds familiar. I know it sounds familiar. It sounds familiar. I can't quite place it. But during his lame duck period, right? Because the election's in November, but he's not going to be done in office until like what, mid-January. So he's got this lame duck period. And he sat around and he schemed. He schemed. He schemed that he really would like to become Chief Justice of the Kansas Supreme Court. But if the court's full, I mean, we had 7 justices and there's no upcoming election, when we just had an election, how could the governor do this? Well, as it turns out, Governor Hall had friends in very high places. In fact, one of his closest friends and his co-conspirator was the actual Chief Justice of the Kansas Supreme Court. His name was William Smith. And apparently Smith had openly supported Governor Hall's re-election campaign. And so when that didn't work out, things got feeling strange. Smith felt like he was kind of out there. But he must have been close to retirement or ready to retire. So what he decides to do is that Chief Justice Smith and Governor Hall essentially resign from their post at almost exactly the same time. And again, this isn't that lame duck. I mean, we only have like this 2-month period, 2.5-month period before the election results and then the new governor is sworn into office. And so during this time, the Chief Justice of the Supreme Court says, no, I'm done. I resign. And Governor Hall is like, I resign too. I resign too. And so the lieutenant governor, whose name was John McEwish, and we have to have governor, right? So he's immediately installed and sworn in to office as the governor of Kansas. And his one and only official act during his 11 days as governor, can you guess, is to appoint Mr. Hall as Chief Justice of the Kansas Supreme Court. I don't even know if Mr. Hall was a lawyer. He must have been. I think there are some restrictions on this, but it was gross. And the people knew it was gross. And it's just this shameless political episode in our history, and it didn't sit well with the people of Kansas. They saw right through it. They saw it immediately. What is going on? And they were so upset that they went through the process to put a ballot measure up for election. They said, let's change our state constitution and move from a partisan election process, which just resulted in this gross shifting of the governor to the Supreme Court justice. And let's change to a merit-based appointment. Let's make sure that the folks installed on our Supreme Court have the merit, the skills, the experience, the knowledge to be sitting on that court, not just a political player who wants to change his scenery. And they did that. So in 1958, our citizens amended the Constitution to say, let's have a merit-based appointment process for our Supreme Court justice. That is still the system that we have in place today. And so, like, very importantly, I feel like like our billboards say, like, we're fed up. We're fed up. That was ridiculous. We're going to change the system, and we're going to make it so that the people who are sat on this court are fair and impartial, and that they're there to be a public servant for the people of Kansas, not there to hold some version of a political office. So let's talk about a little bit how our Kansas Supreme Court process works. We also have a nominating commission, just like I talked about with the district court levels, that they review and interview and scrutinize the applicants. And then in the same process, they're going to submit those 3 finalists to the governor for appointment. And whereas in the Court of Appeals, we have that extra layer where after the governor picks someone, they have to go through Senate confirmation. We do not have to do that with the Kansas Supreme Court. Once the governor makes their selection, that person is sworn in to serve on the court. And so importantly, even though our justices are selected since 1958 and now through a merit-based process with the governor appointment, our voters, our citizens do have a say as to whether to retain that justice during our general election process. And these are retention elections, right? So when you get your ballot, I don't need to tell you guys you're the League of Women Voters. I know that. But for people watching at home who may watch later, you've always heard people at the election office say, make sure to flip over your ballot. And why? And that's because there's these list of strangers you don't know. And you're asked to consider whether that particular judge or justice should be retained. Yes or no? Should they keep their job? And as an attorney, there are ways in the public for you to learn about our judges and justices and to assess, their merit and character for yourself. And so again, this is not something where, yes, if you did no homework and you flip over your ballot, those names are going to be strange to you. It happened to me before I got very civically engaged. I'm like, who are these folks, And I think I made really immature decisions on yes and no. Like I just was not a good voter in that particular time when I was a young person. And I think about that a lot. So now I always make sure I do my homework. What's going to be on my ballot so there's no surprises? And there are websites through the Kansas Bar Association and the court, the court.gov websites themselves that talk about who each judge and justice is, what's their education, their experience. You can find out different decisions that they've authored. Like if you want to actually read some of the case law that they have written and get a feel for what they think, and how they talk to the public, how they talk to litigants. You can actually look them up and do your homework on that. So that retention election happens for everyone, every judge and justice in Kansas, because ultimately there is a merit-based appointment system for all of them, unless you are that district court level judge who's running for election. So they're still running for election, which is your chance to say yes or no to this person, right? But for everyone else who's appointed by the governor in some form or fashion through a nominating commission, you still have all the power. Every 6 years or every 4 years for the Court of Appeals, you can say, I think you're qualified and of good moral character and that you're doing a good job for the people of Kansas. I may not agree with everything you did and said. I'd be the first as a practitioner to say, I don't agree with every decision that comes out of these courts, but I respect the job that they're doing. I think they're doing a good job overall. And I think they have a right to continue their job. That's a decision that all of us across the state can make in these retention elections. And so when you hear people in the public say, well, I say in our Supreme Court, you remind them, we do have a say. Every 6 years, we have a say on whether that person keeps their job. So I would think they have to do a good job of not being too politically motivated, biased, showing that they don't want to follow the law, things that would be red flags for us, right? And if you don't see those red flags or you do your homework and they're not there, then that's maybe hopefully an indication that that person's doing a knowledgeable job on the court and should keep their job in retention. But that's a really important point from today. People are going to talk about how they want to stay in the process. Why shouldn't we get to elect our justices? Why do the lawyers get to decide? That's not true, but that's the talking point. Why do the lawyers get to pick? Well, we don't pick, but the attorneys and the judges are those qualified to become applicants. It's our colleagues and people we've known for decades and decades who are applying to be on the Supreme Court. And so when they say, I'm not willing to not have a vote in the process, you remind them, we do have a vote. We vote on their retention every 6 years. We vote on whether to keep their job. And that's without partisanship, without a ton of money being involved in exchanging hands and campaigning. We can decide whether they keep their job without all of the partisanship. And that brings me to my next point. There's a lot of rules that go with retention elections. And this is what's really important about the merit-based system. The judges and the justices, once they're installed into office, they cannot engage in political activity of any kind, even though they're on the ballot, the same public ballot as Governor Kelly or Governor Brownback. Anybody who's running for office in an election, a partisan election, they're on that same ballot, but they have different rules. They are not allowed to campaign. They cannot ask for money to help them educate the public about their job or how, whether they should be retained. They can't receive money without asking. I think there's a nuance there. You know, I can't ask for funds, but magically I have a pot of funds. No, there's no pot of funds. They can't receive funds. They can't ask for funds. There is no campaign, and they are not allowed to campaign. They can't seek endorsements. They can't go around to, you know, Spirit in Wichita and say, hey, would you endorse my retention for judge? They can't do it. And those organizations are not supposed to publicly, you know, support one judge over another. And now we see that. We see, you guys remember the ad campaigns. Usually there's some, most retention election cycles, but it is possible for the opposition. If someone says, I don't want this person to be on the court anymore, they can create a PAC, a campaign, an ad campaign. They can buy TV ads. They can say, you know, with our really lackadaisical election enforcement rules, they can say and slander anything they want about these justices. And the justices have to be like, I would just like to keep my job, right? Please go to the KBA's website. Or a lot of times what they do is they do a lot of travel during retention election years because they're just trying to help educate folks. This is what the court does. We want you to see us in action. They're traveling a lot right now because they're really trying to show the people of Kansas that, you know, there's a difference from what's going on in Washington versus how courts are conducted here. These are our people, and this is how we conduct ourselves. And they're even holding court in special sessions in different cities across the state. So when it comes to like, what can they do to try to show they're doing a good job? They like bring their job on the road and they just try to show the public that they're conducting a competent, fair, impartial assessment of the cases in front of them. But it's really important, and that's a huge difference. If the amendment passes, and we'll talk about this, that's all out the window. That's all out the window. They can campaign, they can affiliate with a political party, they can be a member or leader in that political party, like have a title within the political party. They definitely can ask for fundraising donations. They can receive, you know, PAC donations. It's kind of a limitless endeavor. That's one of the big important differences with what the proposed amendment would do when it comes to what our justices can do and not do politically. Right now, the answer is nothing. It is a nonpartisan process, no campaigning, no money exchanging hands, no ads, things like that. But I want to make sure we talk about, you know, because this is what's under scrutiny, right? The Kansas Supreme Court's nominating commission and its process. This is what proponents of the amendment want to toss out. They say, we shouldn't have a nominating commission. We shouldn't have it. They want to take the merit-based like application and interview process out of the picture and just hold a straight up public election. So before we can talk about whether the commission is good, bad, or otherwise, like we should understand who's on the commission and how does it function. Our Supreme Court nominating commission is made up of 9 members. 5 are lawyers and 4 are citizens from different sectors of the community where they reside who are not lawyers. And that's like written into the rule. And I think it's because they didn't want 9 lawyers running the show, and they don't want 9 citizens who don't know how the courts work running the show. And so it's really a good split. The 4 lawyers come from one each from our 4 congressional districts. So this is where there's a little bit of interplay. It was a good dividing line. It used to be a very fair geographical dividing line about where folks came from that sit on the commission, right? So there was ensuring geographic diversity. It was ensuring urban and rural split. It was really making sure we had a diverse group. As we get more gerrymandered, I think those lines are getting blurred, but from the commission standpoint, I think it's still a very, very diverse group of people. So one attorney from each of the districts is selected. So how are you selected to be an attorney on the commission? And just like at intervals of 4 or 6 years, just like the judges, there is a vote that happens between all members of the bar. And I don't mean the bar downtown in Revenaugh. We say the bar is our The Kansas Bar, yeah, you don't have to be a member of the Kansas Bar Association. I mean, a lot of folks are, that's our largest association, but you have to have a bar license number. I don't know how to explain it without using the word bar. I keep trying to. So we received our Kansas license to practice law, right? We actually have an individual ID number. And so if you have passed an accredited law school and passed the Kansas bar exam, or you have done sufficient work to cross over from one state to another. My wife, Marissa, just did that. She's like one of our newest Kansas lawyers, but she took a bar exam in Illinois and then also has her license to practice in Washington, D.C. And so she was able to go through kind of a seasoned practitioner application process. They don't, thank God, make you sit for the Kansas bar exam. We would all need 6 months off of work to study for that. But you know, her and many others like her, even though you're not from Kansas, if you want to move to Kansas, practice in Kansas, those kind of things, you can go through a different series of background checks and they make sure your certifications are appropriate. You can also pay a certain amount of fees and then become a Kansas lawyer. But in order to do that, you still have to show you passed all the same tests. Basically, they were just proctored in another state. So anyone with a Kansas bar number can vote. That's what I'm trying to get at. If you have your Kansas license and there's an opening for the commission in your congressional district, then you will get a ballot in the mail asking which of these attorneys who have applied, you know, there's an application process too. You can't just, you know, pick the guy in the office across from you. Like there's an application process. You say, I'd like to sit on the commission. I want to be considered for the commission. Your name goes on a ballot. And it gets sent out to all the lawyers in the district, and then they vote. And whoever has the most votes is picked for the commission in that district. The 4 members of the commission, excuse me, who aren't lawyers, they are appointed by the governor. And I like that process too, because I think from by and large, what we see the governor do is select, and those are all one from each congressional district. So again, it's not just folks from Kansas City, Topeka. She or he, first of all, our governor changes hands all the time, usually every 48 years, right? Lately, every 8 years. So there's, you know, obviously they're a partisan person, but I think that there's just a healthy rotation of folks on the commission, right? And you can't, the governor can't get into office and then just yank everyone off the commission. I think that's really important too. So they can't just jump in, fire all the non-lawyers, and then appoint all their friends to be on the commission, right? So you have terms on the commission like anyone else. And I think it has a very diverse group of people. That 9th spot is also an attorney. That person is selected by all Kansas licensed attorneys in a statewide election. So generally that's someone, in order to just even put your name in for a statewide process, it's usually someone with like just decades and decades of experience and a great reputation. I mean, you don't have someone right out of law school saying, I'd love to be like the lead of the Supreme Court nominating commission. It's kind of I would say a self-disciplined process. Like we really have folks be very measured about, you know, have I practiced long enough? Have I done a good enough job to warrant even trying to get on the court, even trying to be on the commission? So what you usually see is folks with like just a ton of experience, really qualified folks, really measured folks, and we don't often see, I would say, extreme partisans either. It's just folks that really want to serve the public. And so, so that's the makeup of our commission. 4 lawyers, 1 from each district, 4 citizens, 1 from each congressional district appointed by the governor from different sectors of, you know, the community, business, education, things like that. And then the leader of the commission, you know, they lead the process, but they only have 1 vote like everyone else. So there's no special powers that the leader of the commission has, but it is an attorney selected statewide. So when there's an opening on the court, the nomination process is publicly announced, just like, I won't redo it, but just like we talked about with the district courts. And we've had several recent vacancies on the court. Justice Wilson had ALS, had to step down, wonderful person. And so once she stepped down, there was a vacancy on the Supreme Court. And again, there's a public announcement officially declaring the vacancy, and then setting a timeline for individuals who'd like to apply. Especially when it comes to the Supreme Court, you have a lot of lower court judges who want to be considered for the Supreme Court. So it's really normal to have a variety of district court judges, sometimes Court of Appeals judges who think they're ready for the next step, and they apply to be on the Supreme Court. Now, there's not a required hierarchy. You know, do I have to be a district court judge and then a Court of Appeals judge before I go to the Supreme Court? No. Some people do take that path, but it's not a requirement. And in fact, a lot of times the applicants are district court level judges. But they see everything, right? They're the first court. They hear evidence, they try cases, jury trials are happening in front of them. They have a lot of experience as to what it's really like to practice day in and day out in court, and how, you know, constitutional issues come up. You can also sit on the Court of Appeals and apply for the Kansas Supreme Court, and a lot of folks do that and are successful in applying from the Court of Appeals to the Supreme Court. You can also just be an attorney who's practicing in the public. You don't have to be a judge first. You can also be what's called a clerk, and we've seen that a lot, or general counsel. Justice Stegall was general counsel for Sam Brownback, Governor Brownback, and then I think he was appointed to the Court of Appeals. I wasn't crazy about that at the time because I was like, oh, that's cronyism, you know, it's his general counsel. But once he was on the Court of Appeals, he soon after applied to be on the Supreme Court and then was picked for the Supreme Court. So, you know, right, wrong, or otherwise, I think Justice Segal's actually been a very qualified judge. I mean, I don't always agree with what he has to say, but like, I don't look at him and think you have no business being on that court, that you're only there because of a political process. Like, I think he's actually proven and demonstrated that that he has a legal acumen to do the job well. Same with many other justices. There's sometimes a connection to the governor, sometimes there's not at all. You can also clerk. So many people who are picked for the court weren't a practicing lawyer in a private firm like I am. They clerk for the judges and justices, which means they're working right alongside them, drafting the opinions, doing the legal research, trying to figure out the issues in a case. You know, the judge just doesn't show up to court and say next case and then magically understand exactly what to do. So you have a variety of research attorneys, assistants, and then they call them clerks, who are there every day with the court, basically doing the same exercise the judge does publicly, but they're doing it behind the scenes privately. So you do actually see a lot of folks who have served as longtime clerks, you know, 10, 15 years as a clerk in a variety of courtrooms. They'll apply to the court, and many people believe them to be highly qualified to do the job because they've essentially been doing the job behind the scenes for all that time. So like I said, there's no rule about the hierarchy of how you can apply to the Supreme Court. You just have to have a Kansas license to practice. But again, most people are very careful not to just throw their name in and embarrass themselves when they're like a year out of law school or something. So it's generally a very serious panel of applicants for everyone to consider. So then again, they go through this application process. The applications are like a ream of paper. I mean, so that's another thing when people talk about the merit selection process, like how hard are they really looking at these folks? I mean, anyone can put their name in, and it's like, no, this is not something where you get on a portal at ladders.com and say, I'd like to be a Supreme Court justice. It's a really invasive background check. You have to list all the cases that you've been a part of where there's been a public, if you're a judge, can you imagine? Please list all the cases in which you've rendered a public decision. Yeah, it's a database. So these applications are very thick, and they ask questions like, tell me different cases where you had an ethical challenge and how you dealt with it. Tell us about decisions you were made that were reversed on appeal, if any, right? That's important to know. If you keep making decisions that the court above you says weren't right, that's something the commission would want to know. So it's a very, very invasive process. And when people say, oh, this commission's stupid, it's just a 15-minute job interview, it's like, no, the public allotted time is a 30-minute interview, but there's been weeks of work and vetting and meetings with the applicants before that public process. And so it's actually very rigorous. And so that's our commission process. And then again, The commission, just like the district courts, there's 9 applicants, they have to narrow it to 3. Of those three names go to the governor. Then the governor does this intense background and vetting process. And then we'll pick the person that she would like to serve on the court. Right now, there's no Senate confirmation, no political part at all. So really, from start to finish, it's merit-based. Show us that you have the skills, the knowledge, the background, the education, the breadth of experience. You know, the Supreme Court hears all kinds of cases: civil, criminal, child in need of care, prison sentencing, constitutional issues. Like, so if you only did one narrow field of the law, if I was like, well, I've been a bankruptcy attorney for 30 years, that'd be like, great, that will help us with a couple of appeals this year, right? But so usually you're looking for applicants who have a wide variety of that experience over a long period of time, people who have the legal acumen to dive into something new, but also have a substantial foundation on their qualifications and the variety of matters of law that they can handle and approach. So I think it's a good system, but it's also, it's come under scrutiny, and that's why we are now facing this amendment. So I know there's so many more fun things to do on a Saturday. Let's talk about the amendment itself. Now that we're here. Okay. Last year in 2025, why are we having a vote in August, right? How did we get here? And that was last year's legislature, the 2025 legislature, narrowly passed. And when I say narrowly, I mean 1 vote in the House and 1 vote in the Senate. It was so close. And there was a lot of people fighting very hard just to not even have this vote. But unfortunately, by 1 vote in each of the chambers, they passed a resolution called Senate Concurrent Resolution 1611. Everyone calls that SCR 1611 for short. So it explicitly, the language of this resolution calls for the abolishment of the Kansas Supreme Court Nominating Commission, right? So that's the group of 9 people that I talked to you about. That's all the applicants, selects finalists to go to the governor. They said that process is out. We want to replace it with direct, statewide, partisan election of our Supreme Court justices. Now, SCR 1611 is not a law, right? Because we can't change how the Supreme Court functions without a constitutional amendment. So that's why it's called a concurrent resolution. That's how they pass measures that the public then has to vote on in an election. And they specifically said they wanted this election to take place on the August 4th, 2026 primary ballot. And anytime they pick the primary ballot, you got to know that they have a little motivation on their side to try to get less turnout. And it's true, less people turn out for the primaries than the general election. And so that's even more concerning to me, because now you're asking, first you have our whole population, then the voting population, then the population who bothers to go to primaries, then the population who bothers to understand and vote on a constitutional amendment. So this is a huge issue for our state, and there's not going to be a representative majority voting on it, right? And again, this goes back to why the education on these issues is so important. So again, if passed, SCR 1611, if it's passed by the people at this August 4th ballot, it's going to explicitly allow, not just kind of like by abolishing the Supreme Court Nominating Commission, we can now have political activities. Like, it says that the justices and the applicants may engage in political activities. They can run campaigns. They can ask for and receive financial contributions. They can even hold an office in a political party while they are running for judge. And I know you can't read this. Please don't read this. I will read it to you. You know those explanatory statements on the back of the ballot? So they said, question, do we want to have an election for Supreme Court justices? I know it says something different than that. But then there's the explanatory statement, because it's supposed to help you understand, when I vote yes, I'm voting for this. And when I vote no, I'm voting for this. And I can hear the chuckles, and so I know that those statements are not always helpful. Sometimes they make things even more confusing. So I just want to read to you a few pieces of what the explanatory statement says that will be on the actual ballot. And so first it says, this amendment gives the voters the right to elect the justices of the Kansas Supreme Court. They shall serve terms of 6 years, with the elections of justice positions 1, 2, and 3 to occur in 2028, positions 4 and 5 to occur in 2030, and positions 6 and 7 to occur in 2032, and every 6 years thereafter. So it's very explicit. We want to elect Supreme Court justices, right? The term is 6 years. That's the term they serve now. No change there. But what they're saying is, thankfully, thank God, I don't want to have an election in 2028 with all 7 justices and have a brand new Supreme Court. Like that would be chaos. They said, okay, we're going to have the first 3 justices, and we don't know quite how they choose who's in what position. It honestly may go by seniority, where the least seniority has to go first. It's not explicit. We don't know. But positions 1, 2, and 3, whoever they are, will occur in 2028. 4 and 5 will occur in 2030, and then 6 and 7 in 2032. And so every 2 years, we're going to have an election for our Supreme Court, either 2 or 3 spots on our Supreme Court. And like with 7 people total, 2 or 3 spots completely can swing, the ideology of the court one way or another. It could neutralize it, or it could create a really partisan body in a short amount of time. So I just want you to remember how much we love election season. You know how our Congress men and women are constantly running for office because they have to go every 2 years. It's not going to be the same justice all the time, but we are constantly going to have a Supreme Court election every 2 years if this passes. And I think for the public, that's going to get very exhausting very quickly. And then I think once the public's exhausted and no longer listening and paying attention, that's when you can have some really poor outcomes for our state. The explanatory statement goes on. A vote for this proposition, so vote yes, would give Kansas citizens the right to elect Kansas Supreme Court justices as provided by law. Yes, they already said that a few sentences ago, but they say it again. Justices will hold office for terms of 6 years. They already said that too. They say it again. The Kansas Supreme Court Nominating Commission, whose membership consists of a majority of lawyers, those lawyers, would be abolished. So, I mean, the language is important because it's being very explicit. It's being very explicit. We're going to elect for terms of 6 years. We're going to stagger those elections. We are abolishing the nominating commission. So there's not even any wiggle room to try to still have it be a part of the process. It is abolished. Clearly because they think it's horrible that a majority of lawyers help select the justices of the Supreme Court, who are also lawyers. But I digress. Finally, I think the explanatory statement is actually much longer than this. I pulled out the part that I thought was most relevant. It's very long. So that's also going to be.
They're counting on people not reading it.
That's right. That's right. That's exactly right.
And particularly not getting to this part.
That's right. Once you're done, yeah. Especially when you're reading repeat sentences, you're like, okay, I get it, right? But yeah, finally, they say a vote against this proposition would continue the current system in which the Kansas Supreme Court Nominating Commission, whose membership consists of a majority of lawyers, provides the governor a list of 3 individuals to choose from for vacancies on the Kansas Supreme Court. It's kind of a mouthful. And it does obviously emphasize a majority of lawyers. Lawyers are so terrible until you need one. But yeah, I mean, they're clearly trying to make this implication that the lawyers are running away with this, that we're selecting rogue justices. There's
of the people who are currently in our legislative thing, like attorneys or lawyers.
No, actually, no.
Are they
no.
insurance people?
No, that's honestly, if you ask most lawyers, one of the problems with some things that happen in the legislature is that there's not enough lawyers serving in the legislature. And so they're just like, let's just do this thing. And you're like, you guys, this is like dead on arrival. It's so unconstitutional. You can't do this. And they're like, oh, it's fine. And they don't have colleagues who can like actually walk up to them that they respect and say, look, I practice law. Let's fix this. I understand what you want to accomplish. Let's try to make it legal, right? You think that the legislature they can pass anything they want to pass. They can pass something that's factually false. They can say, I declare that 2 + 2 is 4. But also 2 + 2 is 7. Okay, SCR 1611. They can pass that. They can pass it. And I know that feels like, wait, that's crazy, but that's obviously a really silly example. But there are times where they pass things or they try to delve into science. They try to delve into education, into the DMV, into all these agencies. They try to like fix, they want to kill a fly with a hammer, right? They try to fix something and they actually, from a legal perspective, make it so much worse or outright unconstitutional. And that's when you have a problem. That's when a law can be passed, but will it go into effect? Will a court stop it and say it's not legal, so it can't actually be put into enforceable law, or yes, it can. So they can do whatever they want. We do need more lawyers in the legislature. I think that would help, but there's been years where we have none. And we have a couple now, but we had a long absence without lawyers. So I know there's a lot of people talking about, does anyone want to run for the legislature? Because we need more lawyers. And we all looked around and we're like, no, but
I will say, I like your idea of more lawyers. I want competent lawyers in the legislature.
Yeah.
Not failed lawyers who have been kicked out of the bar, who then become.
yeah, that's fair. That's fair.
Is that a stab at someone in our government,
That's
sir?
So I know that I've talked too long. Let's talk about, I'm going to skip ahead. I just want to be very clear on the education piece, because as of 5 minutes from now, when this is finished and we kind of have some Q&A, you are now the educators of your community. You have to go forth and explain to folks, what does this vote actually mean? What is this vote doing? And Debbie has this PowerPoint, so just know that you guys can all print this out. I'm trying to make it as simple as possible. There's pamphlets in the back from Quick and other organizations. You guys made a pamphlet too, I know. So in a nutshell, a yes vote eliminates the Supreme Court nominating commission, which means no more merit selection. Instead, we have statewide partisan elections, and the justices and the candidates for justice can engage in political activity just like any other person running for office in our state, just like the governor, just like our senators. A vote no means please keep the system the way it is. And it's important to know, this is not a vote where there's a change no matter what. What change do you want? Vote no means keep it the same. No changes. We leave our Supreme Court nominating commission. Because we leave that commission in place, it does ensure, historically it proves, it ensures a merit selection process will take place. There is no partisanship, no elections for the court, and no political activities or campaign donations. But the people do get to vote. Remember, we get to vote on retention. And that's the big rub. People are really getting hung up on, well, why can't I vote? What's wrong with me? I can vote for justice. Yeah, you can. On the retention, let's let the experts figure out who is most qualified to sit on the court. The implications of the decisions affect all of us. So let's just not try to play doctor over here because we've watched some Grey's Anatomy. Let's leave it. Well, that's the equivalent. That's the equivalent, right? I watched Law and Order. I can pick a judge. Brett Thompson passed away. He can't run, okay? So that's it. You have some humility to it. I don't try to go play doctor when I go to the doctor's office. I am hopeful that our local communities have picked the best and brightest folks to hire as their doctors. And that's the same concept with the court. We have a commission. It has citizens on it. It's making sure that our best and brightest legal minds who aspire to the court are selected for the court. And you know what? If some crazy person gets in there, we do have a right. We have a right every 6 years to say, I'm not okay with that conduct. It's the same thing that we did in the 50s, right? I'm not okay with this BS vacancy appointment where the governor becomes chief justice. We're changing that system. And they made a system that now has fail-safes, right? We have independent bodies deciding not even who the candidate is, who the finalists are, right? They have no real power other than to narrow the field to 3. It's the governor who picks. In Kansas, famously, we change hands. So no matter where your political ideology is, what ends up happening over time is that you have a fair and balanced court. Nobody's winning all the time. Our justices have held against Republican administrations, Democratic administrations. There's really no pattern that shows this court is loaded with these type of folks who always decide this way and it doesn't reflect the population's ideology. That's actually not true. They're fair and balanced, just like our constituents and our citizens. So I want to close with this, which is, and this is what's scary. What happens? What happens if we go into this system? Because another good talking point is, hey, what Kansas is trying to do, they want it to become Wisconsin. And I don't just mean that as a quick catchphrase, like literally the same system in Wisconsin, which is on a rotation, you have a judge or justice up for re-election and they run a partisan election, right? So you want us to be Wisconsin? Let me tell you what's happened in Wisconsin in the last few years. Wisconsin had a decision from its Supreme Court back in 2014 or 2015 that said, you know what? There's no caps on political contributions to the campaigns anymore, right? Kind of like Citizens United, except at a state level. Once that happened, it became a free-for-all. So in 2023, there was a justice election for the Supreme Court, one single seat, and $51 million was spent on that election. Here's why that matters. Only 45 million of that 51 million came from outside the state of Wisconsin. Okay. Let's fast forward. 2025. Maybe we'll rein it in. Nope. Another seat came up in Wisconsin and they doubled $100 million. Elon Musk gave $20 million of his own money. And last time I checked, he doesn't live there. He shouldn't have an interest in the outcome of a state Supreme Court justice election in Wisconsin, but he was allowed under the law to donate money. So to put that in perspective, Kansas doesn't spend as much money on our issues, right? 2022, our Kansas constitutional amendment, the last time we had the primary vote, 22 million was spent. And that was like an unprecedented amount of money. When Barbara Bollier ran for Senate, that was considered an unprecedented campaign. That was only 14 million. When we run for governor, it doesn't cost that much. It doesn't cost $20 million to run for governor in Kansas. We're going to start seeing 50 plus million, $100+ million in every race. I mean, it's gross because we all know how inflation's working. We're not making more money, right? It's not our money.
How much of the 100 million was out of state?
It's still a vast majority. I don't think I wrote down how much.
It's kind of
But Elon himself had donated 20 million. Yeah, and that's the concept of it's the concept of dark money. You can't, it sounds ominous, but we say it's dark money because you can't actually, even if you knew how to look into the articles of incorporation for all of these different PACs and you follow the rabbit hole, there's still an endpoint where you can't tell.
Can't track it.
You can't track the ultimate source of the funding. And so you just have this ability, especially for billionaires and special interest groups, they can just create a PAC and fund a bunch of money into it. They can donate that to a different PAC, who can donate to a different PAC, who can donate it to the Supreme Court race. And there's no way to know whose money it was. You know, we know that Elon Musk was 1/5 of the fundraising for that seat. I mean, just one human being donated $20 million. So I'm taking over time. Let me close.
That did not get elected.
Huh?
I think that was the big deal.
That's true.
Yeah.
So in both times, and I don't know the split of the money, and let's not kid ourselves. If one political party finds $50 million, the other party better find $50 million, or it does influence the outcome of the race. Not always. It's not always the person who raises the most wins, but it's a giant indicator that they certainly are getting their messaging out more. I mean, that is the influence of the money, that they're allowed to reach more people with their message. So I want to leave you with this. Do we have time for questions?
Very quick question.
Okay. All right, let's do questions. Yeah.
I think right after a justice gets appointed by the governor, don't they have a retention after year one?
Yes.
Yes, yes.
So you don't have to wait 6 years on each.
Thank you. That's a great point. I had to cut that out of my rambling. It is on there. Okay.
We haven't done that slide.
Yeah, so I'll use the example of Justice Larkin Walsh. She was the most recent justice selected for the court, and that was her inauguration was last November. So even though it'll be less than a calendar year that she has sat on the court, her name will be on a retention vote this November. Because even though we have this ballot measure, it won't take effect immediately. So if it passed, it wouldn't be that August 5th, we now have elections and poor Justice Walsh has to put a campaign together in 2 months. I think they said it starts in 2028, right? So Justice Walsh is just sitting for retention. And I think that's a great point, Ann. Like, you don't have to wait. If there was some mistake that the public sniffed out right away that they think wasn't fair or good about the process of selecting a particular justice, you have the next election cycle, whatever that is, it's definitely within 2 years, no matter what, right? That you're going to get to vote to retain or not retain that justice. And then every 6 years thereafter. Yeah.
Okay, so the Governor Smith triple play scandal prompted the change.
That's right.
And what prompted this from the advocates for this ballot measure?
That's a great question. That's a great question. I think that there's been a pattern in the last several years where the legislature is not very happy with some of the big decisions that have come out of the court. And I say that this goes all the way back to the Brownback area. There was the school funding, the public school funding case called Gannon. And Gannon was a challenge to, we just didn't have very much money. We had the tax reforms that really gutted the amount of money that the state had. Of course, they cut public education, and it got so woeful that someone challenged it and said, I think our state constitution guarantees the right to equal and equitable distribution of these K through 12 funds. And not only the funds you have, but there has to be some threshold to make sure you're adequately funding these schools. And that case went on for years and years and years, unfortunately. But there was a series of decisions, and ultimately, at the very end, the court said, legislature, you have not done your job. You have not funded the schools adequately, which means not enough money overall. And you have not distributed it equitably, which means every student across the state should be getting the same access to the same education and materials, that you can't just give all the money to Johnson County. You have to give the same money proportionately to Johnson County that you're giving to Great Bend, right? Not like dollar for dollar, but on a pro rata basis. And they weren't doing that either. And so they said, you've done wrong. And I don't think the legislature liked that. I don't think the legislature liked being forced into putting a certain amount in the budget for education, and they've had to do that for many years. That was one decision. They're upset with the decision that came out a few years ago about reproductive freedom, the decision that a person, that the right to pursue happiness is guaranteed in Article 1 of our Kansas Constitution, states that that includes the right to bodily autonomy. It includes the right to make your own healthcare decisions. And for some individuals, it means the right to terminate a pregnancy if that's their choice, okay? And that obviously was very controversial. The legislature is still trying to work around that decision to this day. And there's been others, but one thing I point out is, like, during COVID, the Supreme Court actually stopped Governor Kelly from doing a lot of executive orders dealing with the COVID pandemic. And so this is not a court that's only deciding one way or the other. They are deciding, I think, I'm not always, like I said, sometimes I think I'm happy, that makes sense. Sometimes I'm like, I hate that. And there's been decisions that have affected my practice that I'm not happy with, but overall, I respect the job that they're doing. I think that it's like when you go to a divorce mediation, I hope not many of you have done this. If like both sides leave kind of grumbly, but like happy it's over, then it was successful, right? And I think that's the core. It's like, what did they do now? And then the next day I'm like, oh, that was helpful. And like, that's the court. And that shows that they're really a nonpartisan body, because I don't see them beholden to any group. And there's enough changeover. There's frankly a lot of changeover in the Supreme Court for a variety of reasons. And so you're getting governors from both sides appointing, and I think it keeps a nice revolving door where partisanship really doesn't have a place there because you have both sides appointing in the process, and the nominating commission tries to wash out and weed out people who are only there for political aim.
Thank you.
Sure.
One more question.
Oh, sure.
One thing that Teresa Woody came to Manhattan and talked about was, and that kind of got through to us, was that if we can appeal to our rural voters especially, that they might get left out of the process because we're not going to be getting a representative from all the different.
Yeah, that's right.
That and also just the testimony from some of the former justices that have said, if I'd known I had to run for this type of office, I would never have thrown my hat in the ring. And some of the very best jurists we've ever had would just say.
Yeah, no, that's right.
I won't put my hat in.
That's a great point.
Yeah.
So yes, that was part of the debate in the legislature when they were deciding to pass SCR 1611. They weren't sure. A lot of our rural representatives were like, look, why aren't you saying where these, you're making these spots, 1, 2, 3, 4, 5, 6, 7. Why can't you say that they have to like come from certain congressional districts? Like, where's the guarantee that I'm gonna, that we have a well-representative Supreme Court? And they're like, oh, we'll figure that out later, which as we know, for their own colleagues, there's no guarantee, right? Like they backstab each other all the time. So there's no written guarantee in the resolution, although it was discussed. And so that's been a major concern. I think the other thing to point out is we do have a lot of rural districts that do elect their district court judges. And so no one is saying that that's wrong. There's no one saying that's wrong. This is your own community, your population. You're able to spread your message around to your neighbors and friends. The judge or justice like lives in the community with you. And so you're able to vet them naturally as them being a part of your residence, right? And so if you want to have local elections for your judges, that's wonderful. And there's nothing wrong with that. And voting no for this Supreme Court measure doesn't mean that your district court elections are inferior or not the right way to go. It's just the political implications are too big. Statewide means no more judges from Great Bend, from Dodge City, they're just not going, they're going to have someone with a law degree who's tangentially qualified just because they got their license at some point, but is a great politician, be propped up. And so you're right. I think the big sacrifice is we won't have our best and brightest. The last 2 openings on the Supreme Court since the amendment was passed to come to vote, nobody from the Court of Appeals put in. And it's because they don't want to lose their jobs, right? If they stay on the Court of Appeals, they're fine. If they apply for the Supreme Court and they get it, they're probably the first election in 2028, and they're not politicians. And also, how are they supposed to do their jobs? Kansas is like 10 hours door to door, right? For me, how are they supposed to be jurists and decide cases and hear cases in the Capitol if they're being asked to campaign for a full year and a half at a time? What, like pretty much their whole job is campaigning, like our congressman, and that it's messy, right? Like we criticize that all the time. Are you really governing? Because you're just fundraising constantly and running constantly. So the same thing would happen, for our justices. And I think this is a really important point to point out. And I think you will lose the representation from rural Kansas. I think you will. That's the natural consequence.
No more.
Sorry.
I do appreciate.
You'll also lose the quality.
Yeah, I think so.
Please join me in thanking Nicole.
Thank you all very much. Thank you. I appreciate it. Let me get this. I heard you had like a full agenda today.
Yeah.
Okay.
Yes. I'm gonna get everybody.
Yeah.